There's also 362, but I think it's 363 if I'm not mistaken.
Yes, Your Honor, 363.
Okay, would counsel note their appearances for the record, please?
Good afternoon, Your Honor. Sarah Lee Smith-Machado on behalf of the state.
Good afternoon, Your Honor. Mike Farrell on behalf of Dale Baranowski.
Okay, this is a continuation of testimony that was taken some time ago. Ms. Machado.
Yes, Your Honor. Before we commence, Your Honor, I am moving to strike certain testimony. The state had objected to testimony relating to the victim having a TRO, a temporary restraining order, signed against her. I object on relevance ground that there was continued questions into whether or not there was to be weapons seized. While the court overruled the objection with respect to the whether or not a temporary restraining order was issued, the specific provisions, specifically the weapons issue, is not relevant to the issue of, it's not relevant to this case. The grounds for admitting the testimony was that it showed bias. What specific provision is checked off does not further demonstrate that bias. In addition, on cross, there was questioning relating to the Burlington County policy for law enforcement officers involved in domestic violence, and again, that was referencing questions relating to the seizure of weapons when law enforcement officers involved in domestic violence in reference to the victim. Again, first, that was not the subject of redirect, so it is beyond the scope of redirect. In addition, it's irrelevant to the issue that we're here today before this court. The issue is whether or not Mr. Baranowski knowingly violated domestic violence restraining order by possessing a firearm, and while bias may be relevant, those details are not. I'd suggest to the court that when we began this trial, defense counsel filed a motion to dismiss based upon selective prosecution. And I suggest to the court that by asking those questions, the defense is trying to lay the groundwork for those issues in an appellate proceeding if we get to that point without the state having the opportunity to present its answer to that allegation. And the testimony that the state has decided is not relevant to any of the issues of this trial, so I would move that that testimony be stricken.
Yes, Your Honor. Actually, my first reaction is that of Sherlock Holmes, which is that sometimes it's most important not what we see or hear, but what we don't see and what we don't hear. Isn't it interesting that the reason, frankly, for the adjournment was so that Ms. Machado could prove that essentially my cross-examination of the officer was incorrect, and that, in fact, the domestic violence order didn't call for the confiscation of her weapon, and that she was going to produce proof and to provide me with copies of that proof, and wanted time to do that, and requested the adjournment of the case in order to do that. In fact, she didn't do that until ultimately there were numerous questions, and then finally provided me with a copy of the applicable restraining order, which is identical to the restraining order which the officer was confronted with, which does require the confiscation of the weapons, as well as a transcript of, in fact, the hearing, which also confirms that it was an order in which those weapons should have been confiscated. So the line of questioning is relevant for purposes of addressing the motive and intent of the witness in saying something other than the truth, which is obviously also always a proper cross-examination. With respect to the cross-examination vis-a-vis the policies of the Burlington County law enforcement and the prosecutor's office concerning, again, the seizure of weapons in domestic violence orders involving police officers, again, the same purpose was to confront the witness with the fact that her weapons were not confiscated when my clients were, to develop what is an appropriate line of cross-examination with respect to any witness, and that is the motive and intent of that witness to color her testimony, in this case, to be more harmful to the defendant than is accurate. And I would also point out that neither one of the motions are timely, in that they should have been made at the time. They're not being made at the time. The whole purpose of the continuance was, in fact, to prove me factually wrong. That did not come out of Ms. Mishaw's mouth, which, frankly, as I indicated, what is most of the time most important in finding the truth is not what is said, but it was not said. And the fact that she did not say that, I think, confirms the fact that, in fact, the order was as I described it, and as I confronted the witness with it. And that is so confirmed with what was sent to me, and the tape, in fact, that was also sent to me. So for all of those reasons, I believe it was appropriate cross-examination, and I ask Your Honor to find not only that the objection is not timely, is not why we continued the case, but also has no basis in fact or law.
Your Honor, if I may respond briefly. Your Honor, I did review the records of both the tape, and I asked Family Case Management to pull the temporary restraining order. And what I did not state, and why I did not raise this, because I didn't think it would be appropriate to go into that whole line, is two things. One, the temporary restraining order, while it does not show in copies, is in two different colored inks. I don't know what happened there. And in fact, if you listen to the tape of the temporary restraining order, all that Judge Bell says is temporary restraining order granted. She does not specify what provisions are applicable. She does not say seize this particular, the weapon. So those are the reasons I did not go into that, specifically because I didn't want to create an issue within Family Case Management as to why the restraining order, is in two different colored inks, why Judge Bell's words did not specify that the specific weapons or any of the particular provisions were to be granted. But at any rate, the question regarding the Burlington County policy went beyond the scope of the redirect. And in addition, the fact that the restraining order was granted is in of itself enough to establish bias. We could go. This is going far asunder as to what this issue is about. The state could proffer testimony regarding the fact that the reasons for the fact that Ms. Kozub's weapons were not seized, specifically because there was an internal investigation in which the allegations were found.
Hold on. Let me cut it off. Let me cut it off right here. As to the objections, number one, it's cross-examination. There's no jury in the box. I'm the trier of fact. So I tend to give counsel a little leeway to cross-examine. Whether, in fact, counsel will be able to persuade me that that is some reason to include it in the court's calculus when it comes to deciding this case is another thing. But it's, in fact, cross-examination. There is an undercurrent in this case that's going to be was argued by prior counsel, and it's going to be argued to the trier of fact be that, in fact, one party in this particular case, since they're both police officers, were treated differently than the other party. All right? Now, I'm not so sure how relevant that is for purposes of determining whether, in fact, there's a violation of a restraining order. But I tend to give people leeway give counsel leeway when it comes to cross-examination. So he can ask those questions. But please, I hope we're not going to put internal Burlington County Prosecutor's Office's procedures on trial here, because it's not really relevant as far as this court's concerned as to whether, in fact, there was a violation of a restraining order. But it's cross-examination. Defense may want to argue that, so I'm going to overrule both objections, and the testimony will remain as is. Thank you.